It doesn't look nice, correct? अगर नहीं होगा तो हम बात करेंगे क्या?
The evidence was edits. Change to defense.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Conviction under which provision?
Under section 302, madam.
302?
Yes, madam.
In view of the good ground shown, the delay of about 151 days
Yes, madam.
in preferring the appeal is condoned. Full stop. The appeal is taken on board. Paragraph, let the lower court records be called for immediately. Full stop. Paper books in adequate number should be prepared within 6 weeks from date. The appeal will appear for hearing 8 weeks hence.
One thing, my lord, there are 3 appellants, my lord. Can there be a joint appeal, my lord? It's criminal is individual rivalry, my lord. It may happen like that, lordship, one appellant succeeds another.
It's a risk that you take. You cannot counter the evidence of a co-accused, co-appellant. You have to sail with all the evidence of the co-appellant.
Yes.
Once they are joined as parties, you cannot sever. It's a great risk in a criminal matter. Consider it. We'll adjourn it. We'll consider it. It's very foolhardy. You cannot question the evidence of a co-accused.
But all of them are submitted the same statement only. Same only.
Sir, consider it.
Yes.
One sentence also, if it is against you, you'll be damned by it. That will amount to admission. Because he's a co-appellant.
Yes.
Cut it out, since the appeal has been preferred by 3 persons convicted inter alia under section 3 and 2 of the Penal Code, counsel seeks, for the appellant seeks time to consider whether individual appeals may be preferred. Full stop. Paragraph. There are pitfalls in joint convicts preferring a single appeal. full stop, paragraph, let the matter appear a week hence.
From the witness, item number 1.
Same?
Well, the positions
Same.
still remains the same.
Very well. Since the relevant issue pending before the Supreme Court has not yet been decided, let these petitions appear in the month of June 2023. Paragraph, the parties will have liberty to mention the matter for earlier listing in the event the Supreme Court matter is decided earlier. Is decided by then. Give a date in June. Yes.
Item number 2.
Yes.
Meet page also.
Milord, respondent number 11 has filed reply yesterday evening, Milord. I have received.
Sorry, my lord, we have filed
Well,
a
since
reply a little
the
late.
state seeks an accommodation as the respondent number 11 has filed an affidavit only yesterday, let the matter appear early next week.
Item number 3.
Meet page also.
Yes, what is the matter?
My lord, this is a matter pertaining to Section 2026 of the Income Tax Act. My
Is
lord.
your microphone on?
My lord,
Is your microphone on?
Your Lordship.
Yes.
My lord, this is demand of payment of income tax by the respondent against the petitioner, my lord, who is a resident of Shillong, belonging to a scheduled tribe community, my lord, Khasi scheduled tribe community, having business interests in the state of Meghalaya. My lord.
In the
State of Meghalaya. My lord.
Tirumalai?
In the state of Meghalaya. My lord.
In the state of Meghalaya? Yes.
My lord, the business of the
So you filed your return?
my lord, I have not filed my return. My lord.
You've not filed your
My
return?
lord.
And you have sought exemption?
My lord, under 2026.
And they have issued you a notice?
My lord.
Where is the notice?
My lord, at page 37, my lord. This is assessment order, my lord.
The assessment order?
My lord.
Oh, so you've gone through the process?
I have gone through the process, my lord. I have filed my reply.
Yes.
I have submitted all my documents showing that I am a scheduled tribe.
So there is a proof against an assessment order. There is or there is an alternative remedy.
My lord.
So why have you come by way for it petition?
My lord, I was delayed sometime in preferring the appeal, my lord, because I was before this court, my lord, because I have received a notice on March. So by April, I was supposed to pay the demand, my lord. So that's why I have come before this honorable court, my lord. If your lordship allows me, my lord, then I can prefer the appeal, my lord.
No, it's your choice. It's your choice. You've lost it, you've lost it.
My lord, the only thing is that there's a delay, my lord. The only thing. There would be
Delay
a
what?
delay in filing the appeal, my lord. Now.
Forget it. That's your choice. You consciously not filed an appeal.
No, my lord.
And preferring a writ petition to ward off Section 14 principle does not apply.
So, my lord, what I would.
Going to a wrong forum does not attract Section 14. Section 14 is when with due diligence you prosecute a matter in good faith.
My lord.
This is neither in good faith nor in due diligence.
My lord,
This is in utter bad faith.
no, my lord, what I was.
No, that's what we will record.
My lord.
You may say no till time the cows come home.
Your lord.
We'll say it's in bad faith.
My lord, would I pray that, my lord, if your lordship permits me, my lord, I can file the appeal against the assessment order.
We'll dismiss the petition on the ground there was an alternative remedy that you did not avail of.
My lord, I would pray that
No.
I maybe allow and
These tricks don't work. These tricks don't work. We'll dismiss the writ petition because there was an alternative. You chose not to. You made a conscious decision. Yeah, you have to abide by that.
My lord, I have approached this honorable court because, my lord, the demand notice was also issued to me, my lord.
Yes.
Against that, my lord.
How is it? The demand notice follows the assessment order.
My lord.
It's consequential. How is it without jurisdiction? When does a writ petition lie? A writ petition lies when you are challenging the jurisdiction, or you are saying that it's fundamentally bad, or you are complaining of complete violation of the principles of natural justice. Even those points can be taken in appeal. But when you take them, the court does not exercise self-restraint as it does when there is an alternative remedy available. These are the only three exceptions.
My lord, my plea was not considered by the respondent, my lord.
Not being considered is not an issue. Anyway, let's answer it once and for all.
If your lordship permits, my lord, I would
No.
that
We'll
I
answer
may be
it.
allowed to file the appeal, my lord, and the delay may be
Not at
controlled,
all.
my lord.
Not at all. You deliberately delayed over here after we, on the first day, expressed an adverse opinion. You fooled around with us, and we are using words advisedly. You played us, now you want a liberty from us. Forget it. Yes.
My lord, I will humbly pray, my lord, if I may be allowed to file an appeal, my lord, against the assessment.
Do it by tactics which are fair.
My lord.
Yes. Let us see the assessment order.
My lord, page 37, Annexure 3, my lord.
This is huge. There are several cases you have relied on.
My lord. Page 37, Annexure 3, my lord.
Yes.
The SSC is an individual and have Indian Oil Corporation Limited LPG distributorship at Knoxtine under ST category in the state of Meghalaya, rural market model. As per information available with the department, SSC has made cash deposit of so-and-so in your saving account maintained with so-and-so, through Karvi Computer Shares Private Limited and invested an amount of 1 crore 80 lakhs on so-and-so, rupees 13 lakhs on so-and-so.
However, SSC did not file return.
My lord. However, the receipt has not filed return, my lord. Thereafter, my
Which
lord,
year are we talking about?
this is 2013,
Assessment,
14,
assessment year 13-14.
my lord. And this notice was issued in the year 2022, my lord. 13, 14, 15, 16, 16, 17, my lord. Section under notice under Section 148 of Income Tax Act 1961 was issued on 27 March 2021, my lord, with the deal number so and so for initiating proceeding in terms of Section 147 of the Act after obtaining an approval of the jurisdictional PCIT under Section 151 of the Act, which requires to file a return of income for assessment year 2013-14 within stipulated time allowed. The reason recorded under Section 148(2) of the Act is reproduced as under. In this case, no return of income was filed for assessment year 2013-14. Information gathered reveals that the assessment SSC has paid an amount of so-and-so for purchase of mutual fund and had high value banking transaction deposit of so-and-so totaling to 8 crore 5 lakhs 57,000. since so-and-so, PAN number so-and-so has not filed a return of income for the year so-and-so, I have reason to believe that income of the assessee chargeable to tax has escaped for the year 2013-14.
So you suffered a 144.
My lord.
By keeping quiet, you suffered a 144.
My lord,
Good.
notice was
Then
not
come to
received.
paragraph 6 in response to 144.
My lord. Dated so-and-so. In response to the said show cause notice under section 144 of the Act, dated so-and-so, SSC has furnished on 3rd February 2022 copy of the Indian Oil Corporation Limited LPG distributorship letter of intent dated 16/6/1999, certificate of importer-exporter code ICA so-and-so, and caste cum residency certificate which was placed on record. Considering the said document, is observed that without filing of return of income, the claim of the SSC could not be considered. Therefore, notice under section 142(1) of the Act for finalizing the pending assessment proceeding issued with the number so-and-so. I thankfully acknowledge your submission filed on today, that is 3rd February 2022, along with copy of the caste cum residency certificate, dealership letter, and ISC which is taken on record. You are aware that you have made cash deposit of so-and-so in saving bank account so-and-so, investment of so much on 3/12/2012, and rupees so-and-so on so-and-so in mutual funds, ICICI Prudential Mutual Fund, and investment of so much on 7/9, Carvi Computer Share Private Limited. My lord, will come below.
Then they've quoted your entire reply under
Your eligibility
142.
for exemption, my lord.
Then 7.1.2.
My lord, if your lordship kindly come to just below at page 41 itself,
Page?
page 41, my lord.
Yes.
Three paragraph above 7, para 7.
Yes.
Your eligibility for exemption of income can be considered only on filing your return of income and other relevant information along with supporting evidence to justify your claim.
Yes.
Without filing of return income, you are personally responsible to forego your eligibility claim under Income Tax Act 1961. So it is clearly asked to file your return of income under Section 148 of Income Tax Act 1961. Then you may proceed to justify your claim under the Income Tax Act 1961 by replying to the show cause notice dated 25/1/2022. Malad, we'll come to page 42, Malad, 7.
Yes, that's your reply. We've seen that.
They have reproduced my entire reply, Malad.
Then your bank statement, yes, your bank statement.
Malad, as I am a Khasi scheduled tribe, Malad, we'll see page 42.
And you have referred to receipts of, so you have mutual fund investment
Malad, my show cause
to the extent of 1 crore 18 crore 18 lakh. Oh, more than that.
1 crore 81 lakhs, Malad.
1 crore 81 lakh.
Malad,
And then you have received payments
Malad.
from one Pamela
Yes, Malad.
amounting to 2 crore 30 in FY 12-13, which corresponds to assessment year 13-14.
13-14, Malad.
Then come to 7.1.4. The SSC has not furnished any document to prove the source of income. Therefore, the sums, so you have to prove source of income.
Malad.
Now, let us see.
I have the show cause, I have filed my show cause, my lord. Come to page 42.
Undisclosed short-term capital gains. Short-term capital gains, yes. $30 lakhs in cash. So some persons have all the business.
Malad.
Over here, There are many people who don't have anything to do, but the same person has LPG, limestone, coal.
My lord, I'm an exporter as well as LPG distributorship.
Over here, there is admission of your dealing with coal.
My lord.
So that we will conduct a separate inquiry as to that.
My lord.
Dr. Mozika, where is the consideration of the exemption in the assessment order?
But our case is, my lord, to claim exemption under section 1026. They must file a return.
Where is that in the order? Your case may be something, but this is an order. This is a quasi-judicial order. It has to be in tune with law, and any objection taken, clearly that objection is taken. Where is that objection dealt with in the assessment order? That objection has been taken as indicated in the replies. She has filed 2 replies. In both cases, she has said, I am a scheduled tribe functioning in a scheduled area, and my entire income comes from that. She has said that. Now, where is a finding to the contrary?
My lord, page 46, my lord.
40?
46.
46, yes.
Para 8.2, my lord. Though is a short 8.2, my lord. Just below the table, my lord.
Failed to file a return of income, that is not.
But therefore, eligibility for exemption of income could not be considered. Without filing of return of income, the SSC herself is responsible to forego her eligible claims under the Income Tax Act. My lord,
what we will do is,
my lord,
we will set aside the assessment part of it.
my lord.
We will ask her to file a return within 2 months. If she files a return, consider it on merits, because it's a mandate, and it's a benefit which is given. The benefit is unlimited. If today I am a scheduled caste operating in a scheduled tribe, operating in a notified area, and I make profit of 100 crores, it's completely exempt.
Provided they give the supporting documents.
If therefore we are telling you the parameters. For instance, I'm into real estate.
My lord.
I build buildings all over the state. The entire state is a notified area, and I make 100 crores a year. You can't touch me. So the only thing that I need is, once I cross the threshold income, I must file a return for you to assess whether I'm entitled to the exemption or not. Up to that we agree with you. But beyond that, if in the assessment, if in the return you find that, all right, the income is all generated here and the exemption applies to the SSE, then she is no longer required to pay anything. But merely because she did not file her return, you should have clearly asked her to file a return. You issued notices to her under 148, she kept quiet, 144, 142.2, but you should have given her an opportunity to file a return. She disclosed the basis of her income and said that I have not maintained books. But even then, you should have afforded her an opportunity to file a return.
Well, let's point out that part, my lord.
We've read the entirety of the order, not missed a single line. Because that is what we were looking for. Come to paragraph 5. This is your best answer to the point. Along with a copy of a notice under 142.1. Paragraph 5, yes, page 39. Since no response has been received from the SSE, a reference has been made to the verification unit through so-and-so. The verification unit has issued a notice along with a copy of notice under section 142.1. Give us the Income Tax Act. That requires the return to be filed under 142.1.
My lord, to this I've filed my response on 3rd of February, my lord. That is admitted by them also.
No, that's a different thing. Come to 142.1, Dr. Mazumdar. See, for the purpose of making an assessment under this Act, the SSE officer may serve a person who has made a return. Usually 139 would have applied. Do you have a copy of the statute? Do you have a copy of the Act?
Yes, ma'am.
Look at 142.1. For the purpose of making an assessment under this Act, the SSE officer may serve on any person who has made a return under section 115 WD or 139. 139 is the usual procedure. Or in whose case the time allowed under 139.1 has expired. In notice requiring him on a date to be therein specified, 1, and you are covered by this, where such person has not made a return, to furnish a return of his income.
My lord.
So that is 142.1.
Yes, my lord.
That file your return. He responded to that, did not file a return. It is there you should have given an opportunity, a further opportunity to file a return.
My lord, at page 38 it appears, my lord.
30?
Page 38.
Yes.
Just above the quoted, there is a quotation, my lord. 2 paragraphs are quoted. Just above that, my lord. I'll start from the first sentence itself. In the light of the information, inquiry was carried out, and thereafter the response for reopening of the case were recorded, and a notice under section 148 of the Income Tax Act was issued on so and so date with the DIN number and so and so for initiating proceedings in terms of section 147 of that after obtaining an approval of the jurisdictional PCIT under section 151(1).
Yes, 148 contemplates a revised return.
With requiring to file her return of income for AY 2013-14 within the stipulated time allowed.
148 contemplates a revised return for something which has escaped assessment and for certain reasons, that provision has undergone a change in 2021. 148 has been amended in 2021,
Yes, sir.
and now you can go back in time. Previously there was a cap, now you can go back in time in respect of subject to certain conditions being fulfilled.
Right.
So 148 per se means file a return, file a revised return. You stick to the same return, then they assess whether any income has escaped assessment, and they either let you go or they immediately impose penalty and interest because of income having escaped assessment.
Right.
And which is again subject to appeal or revision in accordance with law before the relevant commissioner.
Right.
Now, in this case, your 148 notices went unheeded.
Right.
Ultimately, you resorted to 144.
Right.
And then, even then, it went unheeded, and you issued a notice under 142.2.
Right.
142.2, in essence, is of the same effect. If a person has not filed a return within the time stipulated, or if in such a situation as you have done over here, you call upon that person to file a return. It was at the 142.2 stage that she responded. Prior to that, she did not respond. It was about 142.2 being served that she responded. And then she said that I have no books, but these are mine. This is my income. She gave. And then you jump to the inference, which you are entitled to, that in the absence of a return being filed, we are not in a position to consider whether she is entitled to exemption. Therefore, income escaped assessment, to this extent she is entitled to. And you resort to the other applicable provisions, when there are no books, what would be the quantification of profits and things like that. It is at this stage you ought to have clearly, she pleaded that I am not liable to pay income tax. I am entitled to that exemption. It is here that you should have clearly made out that the exemption which is granted is from paying tax. But there is no exemption in 139. Come to 139.
Filing of return. Return of income. Every person, being a company or a firm,
whatever,
being a person, if his total income,
during the previous year, every person, if his total income or the total income of any other person in respect of which he is assessable under this Act, during the previous year exceeded the maximum amount which is not chargeable to income tax, shall on or before, chargeable to income tax is not exemption.
my lord.
It is chargeable to exemption, income tax, but because of a special condition, you are exempted.
My lord.
The wording over here is not which is exempted from income tax. So once your income exceeds the threshold,
My lord.
which is chargeable to income tax,
Thereby,
you are duty bound to file a return.
my lord.
Thereafter, you can claim exemption, you can claim the world in it.
Thereafter, section 10 comes in, my lord.
Thereafter, section 10 will come into play.
It says, my lord, that section 10 starts, incomes not included in total income. In computing the total income of a previous year of any person, any income falling within any of the following clauses shall not be included. So now the question, my lord, because this 1026 exemption is conditional upon fulfilling three requirements, my lord. Residence, status of scheduled tribe, and income must arise from
that notified area.
My lord. Now, there cannot be a self-declaration to that effect that he is meeting or she is meeting all these three criteria. This will be adjusted by the department, my lord, whether any person is fulfilling all these three criteria or not, my lord.
So therefore, again, in this case, we will decide the principle of it,
My lord.
but we will say we are not going into the question as to whether the writ petitioner in this case will be entitled to the exemption or not.
Well,
You will consider that only upon a return being filed, for which we give the writ petitioner a chance. If the writ petitioner does not avail of that chance, the order will become operative. We will keep this order in suspension
my lord.
for a period of 2 months. And if she files a return within such period, then this order will be set aside. But if she does not, then this order will operate.
My lord, because the assessment year was 2013-14, my lord, whether return can be filed.
Sorry.
The assessment years are 2013-14 and 15-16, my lord. So whether a return can be accepted at this time, because the systems are online nowadays, my lord, everything,
That you find out.
my lord.
This is a peculiar case, and if you say return can't be accepted now, then this is a peculiar case.
a peculiar case.
And this will open up the floodgates for you to receive.
True, my lord.
And there will be much greater tax collection.
Yes.
There is a purpose for which a benefit has been conferred.
My lord.
The Aam Admi will not have to do anything because his income will not exceed the chargeable limit.
My lord.
The ordinary person need not. But once it does, whether you are a lawyer or whether you are in a high office, once it does,
Still they are entitled to, but
you're entitled
Maintain
to it.
books
You're
of
entitled to
accounts.
exemption.
Yes.
But that is subject to fulfilling the criteria, and you cannot be the judge of your own cause. It has to be the department which has to judge whether you're entitled to it or not.
but a simple declaration that this income is from advocates' fees will not do. Whether to maintain some kind of books account from whom they receive the money, if there is a substantial amount, and justify that this is the legal fee I have received, and so I am exempted.
You find out.
My lord.
Because if you cannot, then he'll get the benefit.
My lord.
And you have to sit with senior officers and devise a method to, this will not be just one case.
Several cases will come, my lord.
You'll immediately be entitled to issue notices for relevant financial years
Well.
upon this judgment being pronounced. Then there'll be hundreds of returns which have to be filed.
But if Lordship decide the principles, my lord.
No, we'll broadly decide. There is the other aspect of it. There is a non-scheduled tribe, and which is the larger thing. There is a non-scheduled tribe owner of a business who's running the business in the name of
Yes, my lord.
a scheduled tribe employee,
Well.
only to hoodwink the department. Those will come to light. The moment the return is filed, you summon the person.
Will come with the power of attorney.
Those will come to light.
There's a great opportunity for the department, my lord. I'll speak to them, my lord. So matter is fixed after maybe next Monday or something.
We'll give you a fortnight, and also this kind of oligopoly of only a few rich getting richer and cornering all the businesses will also show a reverse trend once this happens.
My lord.
Can I imagine showing 2 crore 30 received from Pamela? Which Pamela? Pamela Bodes?
Malach is the relative of the petitioner, Malach is our aunt.
That is only with regard to one assessment.
If my income tax lawyer saw that I had given a chart of 2 crore 30 received from Pamela, he would whip me before the assessing officer would get a chance.
Malach. Total tax is 8 crore rupees only for 3 assessments here.
And again, you're lucky you got away before you've been caught for 1 financial year. Thereafter, you rectify yourself, but we'll leave it open. We also don't presume anything. We are not going into the issue whether your Bangladesh income has to be regarded as income over here, because that also may not be. So that they will take up and call, and then thereafter courts will decide. You find out, and this will require a mechanism. This will require probably consultation with the CBDT. It will be way beyond any person in Shillong or Northeast or anywhere.
2 weeks time. Malach.
The matter has been heard in part and adjourned for a fortnight for the department to take appropriate instructions. Full stop. Give it after 2 weeks.
Oblige. Oblige.
Yes.
Lordship, this is a state appeal against a state appeal against an acquittal.
Yes. Oh, who's for the?
I'm for the first respondent.
And who's for
I'm okay for the second respondent, my lord.
Very good. Yes.
My lord, I seek for some accommodation in this matter only for today, my lord. Reason being,
Why you're watching the results?
No, my lord. My chamber is in the process of transition, and the diary in which I have noted down all the points of argument, I have not been able to relocate that, my lord.
Very well. Relocate it or start a new diary. We'll give you a week.
My lord, it will suffice, my lord.
Very well. At the request of the second respondent, let the matter stand over for a week.
Deeply obliged, my lord.
Item number 5.